This is part 21 of our You Should Never Buy a Clayton Manufactured Home from Hell. And in this video, we are continuing to expose the fraud and criminal misconduct of the disgusting State Inspector Howard Delk, who works for the corrupt Texas Department of Housing and Community Affairs Manufactured Housing Division. Disgusting Delk's inspection was conducted at the peak of the coronavirus pandemic. Disgusting Delk had open sores on his face, and he continuously and repeatedly picked his nose throughout his inspection. And the only two people that happened to show up to the inspection that day not wearing any type of face coverings was the only two that worked for the state of Texas. Disgusting Delk and Richard Felt. So I guess when you work for the state of Texas, you could do whatever the hell you want, huh? That's not right. In this clip, Disgusting Delk informs me that his responsibilities are to let me know what is a code violation and what is not. And this is it.
My responsibility is to let you know what is a code violation and what isn't. That is not a code violation.
And in this clip, Disgusting Delk informs me that he only has jurisdiction over structural. And this is it.
I know that this happened because the way he brought this in here.
Well, it may be, but I mean, I don't see structural damage. That's what I'm telling you. The only thing I have jurisdiction over is structural.
Now, that's a lie, isn't it, Disgusting Delk? Because you do not have jurisdiction over structural. And your requirements are not to let me know what is a code violation and what isn't. And you sure as hell shouldn't be telling the consumer that things could be fixed with silicone caulk, should you?
And anything that has a little hole in it, I mean, these are ventilated soffits, right?
Yeah, but mud daubers like to get in there.
That's right. And you know how they can fix that? Silicone caulk. They don't have to replace. They know how to fix it.
Your report shall specify each of the consumer's complaints according to section 1201.356. And whether or not the complaint is covered by the manufacturer, the retailer, or the installer's warranty. There was only one structural engineer on the inspection this day, and it's this guy right here. This is Eric Tompax. He's the vice president of NTA. NTA approves the design of the house. They are the structural engineer for the house. And they are the ones to okay the house to leave the factory. But they don't want you to know that. They want you to believe that the sole responsibility lies on these criminal state inspectors from the corrupt Texas Department of Housing and Community Affairs Manufactured Housing Division. Let me give you an example. This is an email we received from Clayton Homes liar attorney Brent Wells on August 27th, 2020, where he says, Mr. and Mrs. Blank, we have just received word that the TDHCA has closed its file on your complaint case number as you see attached. Be that as it may, my clients, Southern Energy Homes and Clayton Manufactured Homes, remain voluntarily committed to perform the repairs designated by the TDHCA's report orders of June 25th, 2020, and at any time you might request before June 25th, 2021. Please just be in communication with me by phone or email before this expiration date of June 25th, 2021, and I will set the repairs up for you. So right here, Clayton Homes liar attorney Brent Wells is telling us that we need to abide by the reports of these criminal state inspectors, and we have till June 25th, 2021 to do so. Now, this was pretty unacceptable. We were not going to accept the 6 petty items in criminal Jimmy Turner's report, just like we're not going to accept the 7 petty items in criminal Disgusting Delt's report. Did they not understand that we were filming everything? So we really went all out on our emails to everybody. And a week and a half later, on September 8th, 2020, we received another email from Clayton Homes lawyer attorney Brent Wells, where he writes, Mr. and Mrs. Blank, please see attached the demand for arbitration which we have filed today to open our case with the American Arbitration Association. You can expect to be contacted by the American Arbitration Association concerning fees, deadlines, and other important procedural matters. He was even kind enough to find us 3 low-cost arbitrators to battle him in court. And he writes, I have researched and identified the following 3 neutral DFW mediators for your consideration. What a guy, huh? So we're guessing the expiration date of June 25th, 2021 is no longer valid. And we were not going to respond to the demand letter for arbitration. So Clayton Homes lawyer attorney Brent Wells proceeded with arbitration without us. And this is what he sought. A, Southern Energy Homes and Clayton Manufactured Homes are both fully discharged from any obligation or liability whatsoever. What would you say if I told you that Southern Energy Homes was owned by Clayton Manufactured Homes? So let's just go to B. Southern Energy Homes has no legal liability whatsoever. I'm pretty sure he said that up here. Then we'll just go to C. Southern Energy Homes owes no monetary damages whatsoever. And then D says Clayton Manufactured Homes has no legal liability whatsoever. And E reads Clayton Manufactured Homes owes no monetary damages whatsoever. So we have Clayton Manufactured Homes personal installer incompetent car mobile home service on video destroying both halves of the house and the concrete foundation, and these people don't care. They're going to fight you. So let's just see what F says. The blanks are permanently enjoined and ordered not to convey any further complaint, criticism, or objection to any person, party, or agency concerning the manufactured home, outside of and following the conclusion of this proceeding by a final award of the arbitrator. So Clayton Homes lawyer attorney Brent Wells wants us not to convey any further complaint or criticism. So let's just see what number 10 says. Southern Energy Homes and Clayton Manufactured Homes hereby apply for an award to them and against the blanks of all costs and reasonable and necessary attorneys' fees as are equitable and just. So not only did we get screwed on the house, Clayton Homes lawyer attorney Brent Wells expects us to retain an attorney to fight him in court, and then wants you to pay for everybody's services and the arbitration fees. And here's my favorite. Southern Energy Homes and Clayton Manufactured Homes hereby pray for each and all of the declaratory adjudications. Who do you suppose they're praying to? Man, I tell you, if my videos don't convince you that you should never buy one of these turds, then you need to get yourself to the doctor and have your head checked out, because nobody should be treated like this. So let's see what the final award of the arbitrator was. So we're just going to go here to number 3. This dispute arises out of the purchase and sale of a manufactured home to the respondents manufactured by claimant Southern Energy Home and sold at retail by Clayton Manufactured Home. Following the purchase and installation of the manufactured home to the respondents filed a consumer complaint under case with the Texas Department of Housing and Community Affairs, raising issues and complaints concerning the quality, construction, and installation of their manufactured home. TDHCA inspectors inspected the manufactured home with respect to this complaint. But the respondents failed and refused to mitigate the issues which were the subject of their complaint by denying access to the manufactured home for repairs. As a result, the TDHCA closed its files and issued a report on or about March 30th, 2020. Now, here's the first problem I see, where it says respondents, meaning my wife and I, filed a consumer complaint under case with the Texas Department of Housing and Community Affairs. We did not file a consumer complaint. It was filed by Clayton Homes lawyer attorney Brent Wells on December 18th, 2019. And he says right here, the purpose of this letter is to request the TDHCA to perform a consumer complaint home inspection of the subject unit as soon as reasonably practicable. The home is installed in Parker County, Texas. The required inspection fee of $150 is enclosed. And on this same day, he circulates a letter where he calls me threatening, vulgar, abusive, violent, and racist. We had never met Clayton Homes lawyer attorney Brent Wells before. He had never met us. And we're guessing he did it because he knew that the first consumer complaint inspector from the Texas Department of Housing and Community Affairs Manufactured Housing Division, Criminal State Inspector Jimmy Turner, was African American. Because I tell you, somebody sure said something to this guy. But he wants us not to convey any complaints or criticism. Do as I say, not as I do. Right, liar Brent Wells? Let's go to the next one. And this is it. Number 4. A second consumer complaint case was filed by respondents before the TDHCA. Once again, allegations were made concerning defects in the home. Experts and inspectors from the TDHCA inspected the home and issued a report. However, respondents again refused to allow repairs of the home and to mitigate the issues which were the subject of their complaint. The TDHCA closed its file concerning the second consumer complaint case on or about August 24th, 2020. The respondents, being my wife and I, were not the ones that opened the second consumer complaint case with the TDHCA. It was opened by Eric Franklin from the TDHCA at the request of Jimmy R. Hicks, who at the time was the Deputy Executive Director of the TDHCA. And this is what he writes. Eric, see below email from Mr. Blank. I'm sure you've already seen a copy before, even though Mr. Blank has not filed a complaint on the required form or online. As a courtesy to Mr. Blank, please open a new consumer complaint regarding his home. Also, please get with Bradley to assign new inspectors to the complaint. I would suggest we send two of our most seasoned inspectors, maybe Howard and Randall. If you have any questions, we can meet tomorrow. Thanks, Eric. He's also the same Jimmy Hicks who signed his name to our statement of ownership that states the house is 2,078 square feet. But our application for statement of ownership states that the house is 2,244 square feet. And they're both wrong, by the way. And Jimmy Hicks is also the one that sent us this email. As I stated in my email, it's a matter of internal policy to invite all parties to the inspection, as it is an opportunity for all to view the findings of the inspector and to gain a full understanding of what must be remedied and or what issues may be out of our jurisdiction. Additionally, since the license holder will be held accountable for making the repairs on jurisdictional findings, it is imperative that they have a full understanding of what must be done in accordance with state and federal law so that your issues will be resolved as quickly as possible. However, there is not a law that makes it mandatory for them to attend. So, Jimmy Hicks, who is now the executive director, is the one that okayed Disgusting Delk to order all parties to endanger the lives of my wife and I in the middle of a pandemic. And the mediator is under the impression that my wife and I were the ones that ordered the first and second consumer complaint inspections. We did not. In fact, there was 3 state inspectors that came to the property, and we have all 3 of them on video committing felonies. And who do you think the expert witness was? Maybe Eric Tompax, the vice president of NTA, who was not supposed to be at this inspection in the first place? Eric Tompax cannot be the expert witness for Clayton Homes lawyer attorney Brent Wells and be the IPIA for this house at the same time. And it says so right here, statute 3286.511, inspector qualifications. Independence is required. The inspector must be independent of the manufacturer, the retailer, the installer, and any other person that has a monetary interest. So this is a huge problem for you, Eric Tompax. So as soon as we're done with Disgusting Delk's report, we're going to go through yours, Eric Tompax. And I can tell you right now, you're going to be in serious trouble. So here's how the arbitrator ruled. Due to the failure of respondents to comply with orders from the Texas Department of Housing and Community Affairs, claimants Southern Energy Homes and Clayton Manufactured Homes are both fully discharged from any obligation or liability to respondents. So I wonder what they're going to do with all the silicone caulk they bought. B, the manufacturer's 1-year limited warranty given by Southern Energy Homes manufacturer has expired and there is no liability under it. And C says the retailer's 1-year installation warranty given by Clayton Manufactured Homes as retailer has expired and there is no liability under it. And then D says any claims that respondents may have or may have had relating to the purchase and sale of the manufactured home, which is the subject of this action, are barred. Then we have 6. Claimants have also sought attorneys' fees as well as fees of the American Arbitration Association and compensation expenses of the arbitrator. While the arbitrator believes that all the attorney fees incurred by counsel for claimants were reasonable and necessary, the arbitrator, acting in his own discretion, denies any award of attorney's fees, filing fees of the American Arbitration Association, or arbitrator fees to claimants. Claimants initiated this action to declare certain rights with respect to the agreement with respondents. Respondents did not contest the relief and did not appear at the hearing. Therefore, and while the arbitrator understands the arguments of claimants as to why they proceeded in this fashion by seeking declaratory relief, the arbitrator believes it would not be equitable or just to assess fees against the respondents based on their choices not to appear and contest the proceedings. And 7 reads, the administrative fees and expenses of the American Arbitration Association totaling $5,750 and the compensation and expenses of the arbitrator totaling $3,272.50 shall be borne as incurred. And number 8 reads, this award is in full and final settlement of all claims submitted to or compulsory in this arbitration, and any and all other relief requested in the case but not explicitly awarded herein is hereby denied. So the arbitrator saved Clayton Manufactured Homes and Southern Energy Homes a lot of silicone caulk. And I can assure you, this is far from over. There's a lot of people that need to be prosecuted, and we want to see to it that it gets done. So we had left off part 20 with discussing Delk either lying or failing to document 14 items in his report. Number 14 was no mention of the gap in the cladding on the back porch overhang, and this is it.
It's not a code violation. But I can tell you,
The only reason you came here
I can
is to
see.
discredit.
No.
Oh, yeah, I can see that, that I wouldn't be happy about that either, but I can't make them do anything about it. Now, can they do something about it? That's an easy fix. It's easy to fix. There's thousands of these issues.
Point it out to me. Go to the next one.
I mean, every
Go to the next one, Paul. Just go to the next one. Go ahead.
Go to the rest.
Quit.
This is how you can expect to be treated by these state inspectors. They are disgusting in more ways than one.
Starting at. Let's go to the next one. You're starting at.
Anyhow, they pay you now.
Yeah, you got to. Now, what do you think I can do about that?
Well, you can say, yeah,
Okay,
that's like crap. What do you think I can do? You can make that it looks like crap. You can admit that it looks
I
like
would
crap.
not like that. I would not like to say, but I'm just a little bit sloppy. But what do you think I can do? Representing the state, what do you think I can do about that? Nothing. You know it. Nothing.
Yeah,
Good.
mud daubers crawl up in there.
Yeah.
I can't. They do.
Yeah. Yeah.
I can't do it.
But something can be done, and it would be very simple.
Well, they've been here 50 times.
Okay, I may have to get here 51 times. 52 times. I may have to come up here. Who knows?
Oh,
You have to get it right. Okay, what's the next thing?
What's on the roof?
What's this here?
Oh, yeah, that's what we want to know. What's that there?
I don't know.
Yeah, I put it there. If you look at that finish there, that one looks brand new. The one in the front looks like it's been there for 40 years.
But it's sequential, isn't it? This is the 4 and that's the 3. But I'm glad you brought that up because I do have to take a picture.
Let's take a picture of the other one.
I think, yeah.
Is it 3 or 5? Right here, Howard. Where you going? Right here. Look at that one. It's brand new. See? It's brand new. Yeah. But you know what? There's no. I know. There's nothing you can do about it. Hey, would have. Okay. Because it does, because in the sun, it's going to fade pretty quick. Yeah.
So Disgusting Dilk made no mention of the HUD labels not matching. So we're going to put that on the board for number 15. No mention of the HUD labels, one being more faded than the other. And I rewound it because I want you to keep an eye on incompetent Gary Carr from Carr Mobile Home Service. Watch his reactions in all this.
The one in the front looks like it's been there for 40 years. But it's sequential, isn't it? This is the 4 and that's the 3. But I'm glad you brought that up because I do have to take a picture of the other one. I think, yeah. Is it 3 or 5?
Now watch Gary Carr. What do you think he's thinking right now?
Right here, Howard. Where you going? Right here. Look at that one. It's brand new. See? It's brand new. Yeah.
Oh, that's a little weird, huh?
I know.
Now we're going to watch this from another angle because I want you to see what Disgusting Delk does. Let's watch.
Let's go on the roof.
What's this here?
Oh yeah, that's what we want to know. What's that there?
I don't know. Well, you got a dot. So.
Yeah, I put it there. If you look at that badge there, that one looks brand new. The one in the front looks like it's been there for 40 years.
But it's sequential, isn't it? This is the 4 and that's the 3. But I'm glad you brought that up because I do have to take a picture of it.
Well, then go take a picture of the other one.
I'm gonna take a picture of both of them. Is the other one 3 or 5?
Right here. Where are you going? It's right here.
Disgusting Delk walked right past the HUD label because he knows that it should be affixed directly opposite of the one in the back. But it's not. It's affixed to the side of the house.
Huh? Look at that one. Looks brand new. Does this one look brand new?
It's discolored.
Yeah.
So Disgusting Delk just admitted that the HUD labels don't match. So let's go back to our prior video, which was part 20, because there's something I want you to see there. And this is it.
So I hope that everybody caught that. The day before we poured the concrete slab, incompetent Carr came to the property. He informed us he had the exact same house, and his was totaled, and he got a really good deal on it. Now, my property is exactly 15 minutes from Clayton's yard. I want to know, how come it took incompetent Carr 3 hours to come with the back half of the house? All the trim on the front of the house is 6 inches. All the trim on the back of the house is 4 inches. All the trim in the kitchen is painted white, while the rest of the house, the trim is wood veneer. And somebody has tampered with the serial number. And it just so happens that incompetent Carr's property is 45 minutes from my property. You think that's why it took them 3 hours to get back here? Maybe.
So now we can add the HUD labels not matching to this, right? So let's see where we're at in all of this. So we have the first consumer complaint inspector from the corrupt Texas Department of Housing and Community Affairs Manufactured Housing Division, State Inspector Tough Guy Jimmy Turner, only ordering 6 measly items in his inspection report to be corrected, while turning a blind eye to 62 of the items we had showed him. Some of these items were extremely serious. And disgusting Delk only orders 7 measly items in his report to be corrected, and either lied about or failed to document 15 of the items that we had showed him. And his inspection has just started. And here's what these crooked state inspectors are required to do. This is section 80.73. The person conducting the inspection shall inspect all matters relating to the home and or the installation of the home set forth in the complaint and any other items raised at the inspection. And their reports shall specify each of the consumer's complaints. So you think they're doing what they're supposed to be doing? They're not. But they expect you to abide by these criminal state inspectors' reports. And we are absolutely going to get to the bottom of this. We still have a long ways to go with disgusting Delk's inspection. So please like, share, and subscribe to our videos, because we do not want them to be able to do this to anybody else. Thanks for watching. See you in a couple weeks.